Hi, good evening to you all. Welcome to the business contractual relationship lesson. And today we are going to discuss about the implied warranties, transfer of the property, and the performance of the contract of sale. Now, during the last week, we discussed about the express terms and conditions, where some of the contract conditions and terms which are mentioned in the contract of sale. So today we are going to consider about the implied warranties. We already discussed about the warranties as well. So we are going to discuss about the implied warranties. Now, the implied warranties are not mentioned in a particular contract, but of course, those are implied in terms. So what do you mean by implied? There are three types of implied warranties in a business contract, or let's say a contract of sale of a good. Warranty of a quiet possession. Now, quiet possession in the sense that should free from the superior power, in the sense, let's say the product is owned by a seller before it transferred to you. Now, once the equity, or let's say the title, or we call it as the property, is transferred to you, it's yours. Now, once it has transferred to you, there should no any title for that particular good by the seller, or there should not be any other person who can claim over it. So that is what we call as warranty of a quiet possession, because that is the freedom which is given to you to use that particular good or the service. That is one. Then the second one is a warranty of the freedom from encumbrances. What do you mean by an encumbrances? As an example, let's say the mortgages. Suppose a business personality who is doing land sales, suppose that he is having a fraud deed, let's say a copy of the deed, and he tries to sell that to you through using that without having enough information, or let's say you are a person or an ignorant buyer who doesn't have any information about this deal. You agree with him to buy that particular land. In that case, the encumbrances refers the mortgage. Suppose that person has already mortgaged that particular land to a bank. In that case, you don't know about this deal. So you will buy it. In a way, that person has given you with an offer of a small price. Because of that, you actually didn't do the legal things and you just bought it. In that case, the title is transferred to you, but of course the actual title is reserved by someone else, that is the bank. So in that case, the title is not transferred to you in actual means. Since the encumbrances is there, even though you have paid to the seller, the title is not transferred to you because the mortgage is with the bank. So because of that, the actual owner or the legal owner of that particular asset is a bank. In that case, you can sue against the seller who sold you the land. That is a condition. Then the third one is warranty of disclosing the dangerous nature of goods to the ignorant buyer. We assume that each and every buyer is ignorant about the product. In some instances, you may have seen some of the electrical equipments contain a caution sticker saying that hazardous electric shock. That is mentioned on the top of the element, or let's say in the particular electric equipment, because to aware you on the possible hazards can be happen through that particular instrument. So that is the liability of the seller to disclose or to explain the hazardous nature of that particular product, which is potential. So if the seller is actually let's suppose that he was not in a position to declare or let's say disclose it, so still the seller be held liable for any damages that are happening to you in the case of that. Right. So we'll move. These were the three things. And we'll move to the transfer of the property. What do you mean by transfer of the property? Here the property includes the title, or we'll call it as the ownership. So when it comes to transfer of the property, the rationale is it simply transfers the ownership from the seller to you as the buyer. When it comes to the property, or let's call it as a title or the ownership, it doesn't matter whether the possession of that particular good is still held with the seller. Doesn't matter. It's not required to be transferred or as let's say delivered to you to get the title of it. So once you have come into an agreement, or let's suppose you had paid for it, at the moment that you paid for it and at the moment that you signed the agreement or came into an agreement, the product will be yours, right? When it comes to the transfer of property, there are some important facts to be remembered. First one is the risk. We call in the law, we call them as a prima facie, right? Which is a Latin phrase, right? Risk or the prima facie passes with the property or the title or the ownership. Let's say in an event where you bought something from a seller, you become the buyer, right? Once you become the buyer, you are totally liable for any defects of such a product once after you bought it, right? You had liable. But in the case that the seller is having a defected good, seller tries to sell it to you, it's not your liability, it's up to the seller, because it's still with the ownership, or it's under the ownership of the seller, because it's not transferred. Without knowing, under the good faith, we call it as under the good faith, without knowing any information, without your notice, you bought a product which is with the defects, and later on you see some of the defects are there. So you complain over the seller, but seller can also be negligent, or let's say he can be exempted from those areas, saying that there were no any defects since you have accepted the product under your title. Be careful with that. When it comes to second circumstance, we call it as actions against the third party. Now let's suppose there are three parties involved in this transaction, in this circumstance: buyer, seller, and the third party, or let's say that is a competitor of the particular seller. In a circumstance where you being the buyer, you bought all the commodities from that particular seller, and still the commodity is held with the seller, right? In that case, let's say the enemy, or let's say the competitor, has made a damage to the particular commodity which is owned by yourself, right? In that case, the seller is not in a position to take the legal actions against the third party, or let's say the competitor, because the property or the title or the ownership is still held with you. So you can sue over the third party who damaged your property, right? So we'll go with the third one: sue over the price, or sue for the price. Seller is only entitled to sue over the price. Buyer cannot, third parties cannot sue over, right? Now when it comes to the insolvency, let's say there are two circumstances where the seller is insolvent or the buyer is insolvent. I told you about the insolvency because let's suppose if a company doesn't have enough or sufficient amounts of assets to pay over their liabilities, that become insolvent. In the case of insolvency, a receiver or a legal personality will be appointed to solve over all these liabilities. Let's suppose in the case of this insolvency of a seller, let's say even though the commodity is sold to another person, the commodity is still held with the seller. In that case, the receiver cannot, or the administrator cannot, claim over that particular commodity to pay over the liabilities of that particular seller, since the the equity, or let's say the title, is almost transferred to the particular buyer, right? I told you, possession doesn't matter for the title of the goods, right? It's not compulsory to be transferred or to be delivered to the doorstep of the buyer. Once the agreement is signed and once the deal is closed, that is a realized deal, in the sense the ownership or the title is almost transferred, right? When it comes to the buyer's case, let's suppose that the buyer has already bought the commodity. So the goods are still held with the party called seller. In that case, the receiver can ask the seller to transfer, or deliver the commodities to the buyer's doorstep, as to resolve all the liabilities of that particular buyer, considering the title is transferred to the buyer, so the commodity is an asset of a buyer. Right. Hope you understood. Then there are two rules to be concerned whenever you think about this, whenever you discuss about this transfer of the property. Right. Title is transferred from seller to the buyer at the time of making the contract or when the goods are delivered and paid for. Right. Now remember, there are two things where you can transfer the property or the transfer of the title of specific and ascertained goods. Right. And when it comes to the other, you can also transfer the property of a good which is still not yet processed or produced, which are known as unascertained or else the future goods. Right? Let's see what are the things that we encounter in those two types of deals. The first one is specific or ascertained products. Right? Specific. You might specifically identify the products to be bought. Right? So the rule one is when goods are in deliverable state. Yeah. If the goods are in the deliverable state, of course, as soon as the contract is made, as soon as the agreement has made, the title transfers to the buyer because those are ready to sell. In the case of rule number two, when goods have to put into the deliverable state, which means a conversion, let's say to make a sort of a let's say a packing effort, right? In that case, that particular product is not ready to sell, right? Though the product is there, it's not ready to sell. It's like a vehicle is there in the a vehicle yard, right? You can also specifically see it, but of course it's not ready to sell since probably be a reconditioned vehicle, though the vehicle is available, but the service hasn't done. So in that case, the vehicle will not be able to deliver, or let's say it's not able to make it a sort of a saleable product, right? In that case, you cannot, the seller is still having the property, you cannot transfer the goods property to the buyer, right? Rule number three, when the goods have to be measured or ascertain the price, in that case also the seller cannot sell the product or transfer the property to the buyer since it's not up to the point of ready to sell or saleable property. It's not a saleable property. Right. Then the rule number four, when goods are delivered on approval. When goods are delivered on approval of the buyer, yes, of course, it's a realized sale. Right. In the case, that is a transfer of the title. It's almost been transferred. The title is already transferred to the buyer. But in the case of delivery, right, there can be two things which are happening as the acceptance of the buyers in the buyer's case, right? Let's say in the case of the acceptance, it can either approval or acceptance expressly accept. As an example, let's say seller has sent some of the commodities to the buyer. Buyer has accepted them by signing all the documents relevant and accepted it. That is called express acceptance. But buyer remains some of the, let's say some of the, or the full amount or the full commodity with him. He holds total commodity with him. In that case also we can assume, that is another presumption, without rejecting the commodity, that one has already accepted it. That is the second circumstance, where the first one was accepted, originally accepted. Second one is signifying the approval without rejecting them, right? Okay, there are two things. Okay, then go for the unascertained and the future goods, which are not yet processed, right? In the unascertained products, let's say those cannot be transferred unless the goods are ascertained or appropriated unconditionally. Let's call it in that way. appropriation. What do you mean by an appropriation? That has to be allocated, right? There are things to be completed to become it a valid appropriation, right? As an example, let's say the first one is goods answered in the description. Now that is related to the description, the sale by the description, right? You being the buyer, you send some description to your seller, right? Or let's say agent, and the particular agent for the particular goods will be sending to you the products, right? But that has to comply the description, whatever you have sent, right? So the goods answered in the description, if the particular commodity contains whatever the things that you explained or described in your description, then it's a valid appropriation. Appropriation must be intentional. Now, if somebody tries to include some of the products into your whatever the commodity unintentionally, that is not a valid appropriation. Because why? Now, suppose that you are expecting, let's say there are three things, right? Let's take three materials, right? Other than that, they cannot include one or any, or else they cannot neglect that particular description, and they cannot ignore that particular description, and they cannot add some sort of other materials into it, right? That is called unintentional, right? Or accidental, right? The third one is assent of the either party is required. What do you mean by assent? The consent of the either party. Either buyer has to be given his or her consent to the seller, or else the seller has to be given the consent to it, or the assent to the buyer to appropriate the, or let's say to allocate that particular commodity. The fourth one is appropriation must be unconditional. You know what the conditional and unconditional is. The appropriation must be unconditional, right? It should not contain any sort of condition. So let's call them as the counter offers or whatever, right? Unconditional, right? Without any influences, right? Okay, fine. Then go for the condition number 1. Delivery to the carrier. Carrier in the sense, the vehicle or the mode of transportation. Now, as an example, when it comes to the seller and buyer relationship, unless otherwise specified by the agreement of sale or by the buyer, the seller is liable to deliver that particular commodity to the buyer. Seller has to deliver them to the buyer, right? That is the general rule. But when it comes to the delivery to the carrier, right? Let's say the buyer is still held liable since the ownership is transferred, right? But let's call it as, like, let's say a rail cargo, right? A train cargo. Let's suppose that the seller has sent the commodity to the train, and once the bill is raised, let's say the cargo bill is raised under the name of that particular buyer, the property is almost transferred because it's under the custody of that particular buyer's name, right? The intention or the purpose should be transmission of the goods to the buyer. That is a clear intention, right? Then in the condition number 2, the right of the disposal. What do you mean by right of disposal? Now, seller reserves the right to dispose the commodities unless the conditions which are included in the agreement are not satisfied by the other party. Let's say, even though you being the buyer, you promised him to pay a sum to release that particular commodity from his custody, but still not made the payment. So because of that, the seller reserved the right to dispose it. That has to be actually expressed in the agreement, or we'll call it as the contract of sale. That has to be expressly entered into it, right? Then rules of transfer of the title. What do you mean by this? Now, when it comes to the transfer of the title, let's suppose I am the seller, you are the buyer. I cannot transfer you anything which was not owned, right? In that case, we call it as mnemonic called non-habit. That is called no one can give what he has not got. So something has to be with me to transfer it to you. If I'm not having an ownership, I cannot transfer the ownership of something to you. That is the case, right? So a seller must be having the ownership over something. That is what we call as a superior ownership, right? The superior ownership should be with a particular seller to transfer the title or the property or the ownership of that particular good to the buyer, right? So then, transfer of the title by non-owners. Now there are 7 types of circumstances where there can be non-owners, right? We'll first see them. An unauthorized sale by a mercantile agent, transfer of title by estoppel, sale by a joint owner, sale by person in possession under the avoidable contract, sale by seller in the possession after the sale, sale by buyer in possession after the agreement to buy, resale by unpaid seller. In that case, the transfer of the title by the non-owners, the first one is an unauthorized sale by a mercantile agent. Right? A mercantile agent. Now, let's suppose if a company is selling some of the commodities to their consumers, right? They might be having, some of the mercantile agents, right? Agentships. So those agents are legally entitled to receive whatever the payments from the consumers of that particular seller, right? And also to deliver the goods and services which are manufactured or which are distributed by the particular seller on behalf of the seller, right? That is what you call as agency. So in that case, mercantile agent reserves the right to sell a product or service, we call it, right? Even without the notice of the seller, the original seller, right? In that case, let's say the mercantile agent can sell even without the authority from the principal. We call the original seller as the principal here. There are 3 conditions to be satisfied in this case. The first one is should possess the goods or the documents. Now, whatever the documents which are related to the title of the transfer of the property, or let's say the transfer of the property of the goods, or else the person or the mercantile agent should possess those commodities with them to sell it. The first one. Second one is sell the goods in ordinary course of business. That's a sort of a mere business, right? It's a general process of doing business of it, right? Agency. Then the third one is buyer should act in good faith without having any notice. Now, buyer doesn't know, that person is not having the, let's say, without any information only they are giving, right? Now, this in the case of mercantile agent is trying to sell some of the commodity without notifying the actual seller, or let's call him as a principal, right? The buyer should act in good faith, right? He trusts that particular mercantile agent, and also he doesn't know about that, right? If these 3 things are completed, so of course, even though there's no any sort of authority from the principal to the seller, or the seller to the mercantile agent, the mercantile agent reserves the right to sell the products on behalf of the seller to its consumers or the customers. That is the first one. Then the second one is transfer of the title by estoppel. We discussed about the promissory estoppels in our previous lesson, so I think you can understand what I am saying here. Right. Then the third one is sale by the joint owner. Joint owner, in the sense, it's a similar type of ownership which is to the co-owner. Co-owner is a person who partly owns something. Let's say there's a product which owns by 3 people, which is owned by 3 people, right? So in that case, we'll say buying from a co-owner will, now as I told you earlier, if something is to sell to somebody else, you should be having the ownership over it, right? Now let's suppose it's like an assignment, right? If you are having 50% of share percentile held with you as a shareholder, you can sell that particular 50% of a shares to another, which he becomes the shareholder of that particular company for 50% of the total shares. It's like that. When it comes to sale by the joint owner, once you sold, let's suppose that once you sold it, in that case, the person who bought it becomes a co-owner again, not the actual or the fully owned. He's not going to fully own the whatever the commodity that he bought, right? So he's going to just be a co-owner as like you were, right? Then the fourth one is sale by person in possession under a voidable contract. Let's suppose because of some of the reasons, there are so many reasons to become a contract voidable. Now, in a case of a voidable contract, let's suppose a person without having any notice, without having much awareness about this voidability, right? The volatility of this, what you call the conditions and whatever things included, somebody will buy some sort of a product from you, right? You know that particular agreement or the contract which is signed on that particular commodity or the particular good is about to void, right? Which are voidable. Now, if somebody if somebody bought it before the contract is resigned, right? We call it as resignment, right? In that case, before the resident, that case we apply the bona fide principle, and we assume that person has bought that particular product from the particular seller or the person who act as the seller or person who had the possession before the title is transferred under without notice of such sort of a defect, or else with the good faith, right? It has to be actually the good faith has to be there with the notice. I mean, with the ignorant buyer condition. Like let's say that the person doesn't have any sort of a knowledge about this previous transaction, or let's say the actual possession of the good, actual title of the good. So in that case, buyer actually, let's think a person, let's get an example. There are three people known as A, B, and C. Now A owns a land, right? B is a person. A gives his land, the deed of his land to B under the trust. But breaching the trust, B sells this particular land to another, let's call C, right? Without knowing the actual ownership of that thing, C will buy it from B, right? If somebody say you know the asset has not transferred yet, in the sense you will buy it as you're the second owner, right? In that case, the title is transferred under the bona fide rule, where the buyer actually doesn't know about the ownership over the product, as well as he's having the good faith. Under that condition, the title owner, or let's call him as the principal, cannot sue over the person or cannot claim the damages from the person who bought it. But of course, the person who act in middle is held liable, because why? That person has fraudulently acted in the case, the circumstance. So under that transfer of the title, the person who bought recently, the person who bought the land recently become the owner of that particular land, right? And sale by seller in possession after sale. It's normally, the seller cannot sell any sort of a commodity which is held even after the sale, unless otherwise he agreed with the buyer for a delivery of that particular commodity by the buyer him or herself. As an example, let's suppose when the event of the transaction is made, let's say it can be a sale or contracted to sell, right? In that case, let's say if the buyer did not actually demand for the transportation, or let's say the delivery. In that case, the buyer will agree with the seller to do the delivery part himself. In that case, the buyer be liable for the delivery, but of course for the damages or the case of resale, right? Presumption, under the presumption, the sellers can resell, right? That sort of a reselling is considered as it's not legal, but the buyer is held liable, right? The sixth one is sale by the buyer in possession after the agreement to buy, right? Let's suppose again there are three parties known as A, B and C. Now A is the seller, B is the second seller, B agrees with A to buy a particular commodity, and because of that he gets the possession of that particular goods, right? It's still not transferred the title, but of course he possessed the goods with him, and with that, since he having the promise with that particular A, B tries to sell this to C, and ultimately C bought these products, right? What is happening? Sale by the buyer in possession after the agreement to buy. There's an agreement, but of course after the agreement, in the sense it's not actually an agreement, right? Because you didn't sign anything, you didn't pay for it, you didn't have any consideration, you just promised to buy it, but of course you finally possess the commodity, then after that you sold it to another person, and actually the agreement, since the agreement is not existing, so that is considered as an option to buy, right? In that case, option to buy is not an agreement, right? Resell by an unpaid seller. Now as an example, let's suppose even though you promised to the seller, but if the seller didn't receive any sort of a money up to a recent time limit, let's call it as a considerable time limit or reasonable time limit, so the seller can decide over the commodity and can sell it to another, right? Even though it is specifically it's ascertained to you, right? Fine. Then the next one is performance of contract of sale. Performance in the sense it's actually the delivering part of the commodity to the buyer, right? Now when it comes to the performance of the contract of sale, the seller is still liable to perform the contract to deliver the particular commodity to the doorsteps of the buyer, but it is, if it is specified in the terms or the conditions of the contract of sale that the buyer is liable for the delivery thing, the buyer is liable, right? But remember, buyer can demand for the delivery from the seller, right? If the buyer demands it, then the seller has to, like, if the seller agrees to give it to the give the delivery service to the buyer, of course they can mutually come into an agreement of delivery, right? The next one is a delivery. What do you mean by delivery? It's a voluntary transfer of the possession of goods from one person to another, right? It will deliver from one person to another. Now delivery can be actual delivery, symbolic delivery, or else the constructive delivery. In the sense, the first one is the actual delivery, where if you are the seller, there's a buyer, so you as a seller, you deliver some of the commodity from your warehouse to the buyer's place, right? That is actual delivery. Second one is you have so much of commodities, right? You symbolically deliver the commodity to the particular buyer through what? Let's suppose you're giving the symbolically you give a key, or let's say the warehouse key to the buyer. In that case, all the commodities which are inside the warehouse will be, the title is almost transferred, the performance is made, right? The symbolic delivery. Third one is a constructive delivery. On behalf of you, if somebody is having a warehouse, let's suppose that on behalf of you, he or she is maintaining a common stock, right? That stock is held with him or her on behalf of you. Once you released, let's say you made a sale, and once you released your delivery order, we call it as DO, right? Since the title is transferred, but still the possession is still held with that constructive party known as the third party. So he does a constructive delivery by remaining the stock for the use of the buyer. Now previously he held the stock for you as a seller. Now even though the title is transferred to the buyer, that constructive party or third party still held the possession of that particular commodity with him or her as representing the ownership of the buyer. So the buyers can give the delivery note and get it. Right, fine. Then rules of delivery of goods. Right? Delivery, as I told you, it can be either actual, symbolic, or else constructive. Delivery date and the payment are basically the concurrent things, right? It has to be happen simultaneously, and actually the goods cannot be partly delivered, right? Let's suppose that if somebody has agreed with the seller to pay the amount, or let's say the total value of the asset in so many installments, right? But the seller held liable to deliver the particular good in full to the buyer, even though he has made a single payment, single installment, right? If the buyer has specifically told about the partial installation, let's say in cases of installation of machinery, installation of plants, especially the production plants, they are having some of the steps of installations, right? There are stages of installations. In that case, you have to have a proper agreement with the seller and the buyer, between you both, to mutually express the terms and conditions pertaining to the part installations and the payments related to that each and every part of installation, right? Then the time of the delivery is something like it's mentioned in the law of sale of goods, and also in the common law it's mentioned as the commercial law, it's mentioned as a sufficient time. It's a reasonable time. There's no any sort of specific time duration mentioned in the law. So based on the nature of the product, it can be different, right? Then the place of the delivery can be one of the three things, where normally if somebody is going to draft a contract of sale, the place of delivery has to be mentioned in that particular contract of sale. But in the case where the place is not mentioned in the contract of sale, then the law intends to the buyer or the seller to transfer the property or to perform this performance of contract through delivering to three destinations. What are those? In the case of when the cash sale, let's say it's a sort of a definite sale, you can send, or you being the seller, you can send the commodities to the place which the payment has been made, and the buyer was there when the time of the particular sale. The second one is the place which the time of the agreement to sell. Now when they have come into an agreement, right, the place which you signed the agreement, or which you came into the agreement, is the place to deliver. The third one is place which they are manufactured and produced, in the case of the future goods especially. Right. So there are some rules applied in the case of possession of the goods by a third party, as well as normally the expense of the delivery has to be borne by the seller by default. But of course, in the case of specific contracts, specified terms and conditions, it's up to the seller and the buyer to be bargained on the delivery expenses. In some cases, we can see even the buyer is bearing the cost. Of course, delivery of wrong quantity or different different quality will affect to reject or to refuse the order. In that case, let's say the buyer can do three things: either to reject the whole, or to accept the all, or else to accept the quantity which are prescribed under the description of sale and to reject whatever not in the list, right? Then I discussed about the delivery, about this installment deliveries as well. And when it comes to delivery to the courier or the wharfinger, we can say there are two types of things. Remember, the first one is seller's duty, the other one is a sea transit. Now, when it comes to seller's duty, it's obviously by the law, it says by default, it's the responsibility of the seller to deliver the goods to the buyer unless otherwise specified in the terms and the conditions of the contract. But when it comes to the sea transit, once the goods are dispatched from the ports to the port, so even buyer and the seller has to mutually agree and get necessary actions to ensure that particular commodity or the sea cargo. In the case of loss of or the damages, the insurance will pay the damages to you, right? Right. In the rules of delivery, unless otherwise specified in the contract, the seller held liable for the delivery. But of course, if the buyer has specified in the contract of sale that the delivery by him or herself, so the buyer has to give that facility to the seller and get things delivered to his place. But of course, in the case of refusal, the seller will not be held liable under any circumstance. Right. Then the acceptance of the delivery by the buyer. What do you mean by acceptance? Right. There are three conditions where when the buyer intimates that the buyer has accepted the goods, right? It's one way of acceptance. Second way is when the buyer does any act in relation to the goods which is inconsistent with the ownership of the seller. In that case, let's say if buyer has taken some of the commodity and refused something, then the commodity will be less whatever the commodity that has been sent by the seller to the buyer, right? So which means that makes a sort of an inconsistent in the stock, right? That case, that is also an acceptance it's a partial acceptance, right? The third case is when after the lapse of the reasonable time, retaining them without intimating that is rejected. In the case impliedly, it is accepted commodity. It will be an accepted commodity. Right. So these were the things that I decided to discuss today. So thank you very much for attending to the business contractual relationship lecture. Thank you very much.